On behalf of Dean Hammoudi and the College of Law Faculty and Administration, I'm very pleased to welcome you to the 2025 Robert S. Marx Lecture at the University of Cincinnati College of Law. Dean Hammoudi is in New York today. He sends his regrets that he is unable to join us for this event. The Robert S. Marx Lecture was established by Judge Marx to enrich the curriculum of the College of Law by bringing to the law school the scholarship and learning of eminent persons in various fields of law. Judge Marx was a graduate of the College of Law and an outstanding member of the Cincinnati Bar for 51 years. The lecture was endowed in 1989 through the generosity of the Robert S. Marx Testamentary Trustees, and we are very grateful for their support. Our lecturer this year is Jeffrey S. Sutton, Chief Judge of the United States Court of Appeals for the Sixth Circuit. He was appointed to the bench in 2003 by President George W. Bush and became Chief Judge in 2021. Chief Judge Sutton has served as chair of the Federal Judicial Conference Committee on Rules of Practice and Procedure, chair of the Advisory Committee on Appellate Rules, and chair of the Supreme Court Fellows Commission. He currently serves as chair of the Executive Committee of the Judicial Conference of the United States. Chief Judge Sutton is also an experienced educator and a recognized scholar. Since 1993, he has been adjunct professor at his alma mater, the Ohio State University College of Law, where he teaches seminars on state constitutional law, the United States Supreme Court, and appellate advocacy. He also teaches a class on state constitutional law at Harvard Law School. Among many other publications, Judge Sutton is the author of Who Decides? States as Laboratories of Constitutional Experimentation and 51 Imperfect Solutions, States and the Making of American Constitutional Law. He is the co-author of a casebook, State Constitutional Law, The Modern Experience, as well as The Law of Judicial Precedent. In addition, he is the co-editor of The Essential Scalia on the Constitution, the Courts, and the Rule of Law. In 2006, Chief Judge Sutton was elected to the American Law Institute, and in 2017, he was elected to its council. Please join me in welcoming Chief Judge Sutton.
Thank you, Dean. It's an honor to be with you. Thank you for that warm introduction, and thank you for scheduling this during a sitting week. So all I have to do when I'm done is go to the courthouse a few miles down the road. So let me start with a story that probably doesn't seem relevant, but I hope I'll be able to show why it is relevant. And it's very hard to find a tasteful COVID story, but I'll let you be the judge whether this is tasteful or not. As the Dean pointed out, I teach at Ohio State quite a bit, and COVID was no picnic if you were running an educational institution. If you recall, it started in March, April of 2020. We shut everything down. It was all remote learning. And in the fall of 2020, educational institutions did the best they could, and I think Ohio State was just like University of Cincinnati, tried to be all things to all people. Well, what did that mean? That meant that the students could learn virtually, remotely, or they could show up live, suitably masked, distanced, and so forth. Same for the professors. They were allowed to teach remotely, or they could teach live. So I had a seminar starting that fall, 20 students in the seminar. I learned half wanted to learn remotely, and the other half wanted to be live. They put the 10 live. I figured, well, if 10 want to show up, I'll show up. They put the 10 of us in a room this big. In fact, it might even be a little bigger. So we were getting an A on the spacing situation. It was very complicated to teach these classes in lots of ways. But for starters, the technology is not a picnic. You had to have, a screen there. You had to stay behind the screen. The students had to have their screens, and then behind us was, whatever, a Brady Bunch, so all of the people remote in their different squares up there. So I get there early for this 5 o'clock class. All the IT people, they're doing their wonders, and we're ready to go at 5. And then I realize I've made a potentially fatal mistake, which is it's very hard to teach for 2 hours with a mask on. That just you get a really dry throat, and it's just uncomfortable. And so your friend is a bottle of water, indispensable friend. And I sometimes can be a little mischievous with my bottles of water. I take the mask down, I drink, I forget to put it back up for a little while just to give me a break. So I really was unhappy I had not brought a bottle of water. But in Ohio State's infinite wisdom, they had given the professors a COVID protection bag, a big bag. Of course, it had Ohio State masks, it had wipes, it had long instructions about how not to get COVID. And then, like manna from heaven, there was a 6-ounce bottle of water in the bottom. So I quickly took it, uncorked it, big swig, not water. So, proving your speaker is quite altruistic, I swallowed the sanitizer, a very big swig of sanitizer. And then it's quite obvious already how quick thinking I am. So my quick thinking abilities kick in, and I go back to seventh grade science. And I say to myself, yeah, that's right. There are two types of poison, one you extract and one you dilute with water. And I'm saying, this has got to be a dilution situation. I don't really want to extract this. So now remember, everybody's looking at me. We've got the 10 online, we've got the 10 right there. And I'm pausing for a second. You know, the honest thing to do would be to tell them what's just happened, maybe even wise as a medical matter. If I fell over, they would know why I fell over. But I've got a lot of pride and a little bit of a false streak. I just was not prepared to tell them what I just done. And I guess I was being slightly opportunistic because at Ohio State, I assume like Cincinnati, you have an add drop window for a week or two. And I just found myself wondering, like, who takes a class from a guy that drinks sanitizer? And I just don't want that to happen. So I said, I think this is information they're not going to get today. So I calmly, as if nothing's going on, walk out of the big auditorium, literally a little bigger than this, and malpractice wise, Ohio State still has the fountains going. I don't know why. I thought I was going to be drinking out of a faucet. So drink, drink, drink lots of water, go back in, teach the 2-hour class. I don't faint, I don't die. I do have a terrible of a taste in my mouth. So this is just not worth doing. But there's a group of you with a slight mischievous streak who are saying, well, Jeff, this, bit of a silver lining here, right? I mean, you just took a very big swig of very high alcohol content liquid, kind of takes the edge off the first class. Back to seventh grade science. Don't say you didn't learn anything today. Another seventh grade science tip, it turns out there are two types of alcohol. Sanitizer does not have any of the properties with which some of you are familiar, so it ain't worth it at every turn. So, how could this possibly be relevant to this talk other than I really like to lower the expectations for a talk? That story really does lower them and obviously makes it a lot easier to meet them at this point with the bar so low. But there is a part of the story that does bear on my talk, and that's the COVID experience. By the way, you be the judge whether that was a tasteful COVID story. But COVID is really interesting looking back on it. As much as it was tragic, hurtful, it's we're still dealing with features of it. There is a part of it that does help us think a little bit about how American federalism works and this great question in American history: what policy problems do we resolve nationally, and which ones do we resolve locally? I mean, just to pause there, it really is the great question in American history. There's no time from 1776 to the present where that is not an epic topic going on in American government. Is this a problem that we've got to nationalize the answer to? Or is this a problem best resolved locally? And we have preferences. We probably are in an era where, at least the last several decades, we probably prioritize more national solutions. I wonder if we're entering an era where we might be prioritizing most local solutions. I have no idea. What I do have a deep conviction about it is the American story. In fact, it's really the American question. I mean, federalism is a question, it's not an answer. The question is just always to ask yourself, what's best for my client, my interest group, my view as a citizen, in terms of fixing whatever this problem is we have today or in the future? Well, COVID illustrates that perfectly. We would all look back on that experience and say there were some things that had to be handled nationally. Ohio and Kentucky and Indiana were not going to band together and productively bring to market a vaccine. That's delusional. That was a job for the national government, if it was a job at all. And it's actually, however this is all going to play out, it's pretty remarkable how quickly they did bring vaccines to market. But due to resources, the expertise of the national agencies, there was no other way to look at this. So we may have some people that don't like vaccines, but everyone agrees if you were going to produce a vaccine, that was a national solution to that particular slice of the problem. I also think we would all agree, looking back on it, that there were some things that should have been handled locally and were handled locally. Masking requirements, vaccine requirements, shutting down schools. How do you open schools? It would have been a catastrophe if we had decided that every public elementary school in this country had to live under the same rules. Why? No one knew the answer. You never do an experiment on 330 million people, 51 jurisdictions, when you don't know the answer. I mean, the beauty of federalism is when you just don't know what to do with an existential threat, it's a very good idea to let different states, even localities, experiment with what to do. And you can illustrate this, and I'm not picking on this governor, I won't even name the governor, because there before the grace of God go all of us in terms of having to deal with some of those problems, particularly early on, March, April, May of 2020. But if you remember early on, you'd get these terrible stories, whether you're reading blogs or the nightly news, about hospitals running out of emergency beds for people suffering from COVID. I mean, it's just a really panicky thing to notice. Well, what did they do in New York? They realized, hey, we've got no beds left in the hospital or the emergency room, but we do have some skilled nursing um, facilities that have open beds. We're noticing a lot of elderly people here. Why don't we just move some of the elderly people to the skilled nursing? Well, it only took a week or two to realize what a catastrophe that was, because the people most vulnerable to COVID were, of course, the elderly. Can you imagine looking back on it if in March or April of 2020 we decided that the president of the United States should make this kind of a decision? I mean, it would have just thousands more people would have died. So, looking back on it, we can say, yeah, there were some things we handle nationally, there were some things we handle locally. Sometimes it's not binary, it's not either or. Sometimes a winning insight emerges. This is the whole Justice Brandeis point, that sometimes the states are super productive laboratories of experimentation. A winning insight emerges, then by all means nationalize it. Now, in talking about COVID, in mentioning Justice Brandeis, I'm picking up on something, a familiar theme that I think you all know. I think it remains something we still as Americans agree about, that in sorting out what type of legislation to enact, locally or nationally, it's wise to use the laboratories of experimentation. If you don't know what to do with a very difficult problem, why would you just try one experiment on everybody? Way better to use our 50 states, our thousands of cities. And again, if a winning legislative idea emerges, then you can nationalize it through Congress. Everything I'm going to say for the rest of the day, everything I've written about, it seems like my whole career has been focused on this one point. Why are we not taking the Brandeis insight, lessons from things like COVID, and doing exactly the same things with the courts? One of the things that really bothers me about America today, and I think is polarization. And I think one of the things fueling polarization is this preoccupation with nationalizing every constitutional right. In this country, we have 51 constitutions, not just one. We have 51 high courts. And as with problems like COVID, it's not always obvious exactly how to construe a generally worded constitutional guarantee. Um, if I think of my friends, I live in Bexley, a east side suburb of Columbus, and I happen to have lots of friends who are very strong views about this issue or that issue. I love them for it. But I will tell you, they annoy me. And the way they annoy me is they wake up in the morning and they care deeply about issue X. And I love them for it because they want to start by solving issue X in our community of Bexley, then within Franklin County, and then within the state of Ohio. So far, so good. But what bothers me is they won't stop there. They won't have the courage of their convictions, having solved their problem through a state court decision, state legislation. They now want to impose their idea on the other 49 states. Now, that's fine. Good for them. They have the courage of their convictions. They think they're right. But of course, they don't let these other states do it on their own through their own state courts, their own state constitutions, or their own state legislatures. They nationalize it through a US Supreme Court decision, which removes democracy from the field and gives them this victory that doesn't just protect the right they care dearly about in Ohio, it protects them in all 50 states. That's a very happy day for them. But what they can't understand is when people in other states, Arkansas, Colorado, California, use the same playbook and then impose their preferred right on Ohioans. Suddenly they're deeply resentful, saying, who do they think they are? Why are they telling us how to handle issue Y? We were doing just fine by ourselves. And they can't remember what they just did themselves to the people of Arkansas, Colorado, or California. And I just find myself saying, you hypocrite. I mean, you can't live in a world where you only get to do the imposing and no one else gets to use that playbook and do it to you. To me, that is driving a lot of polarization in this country and leading to a lot of resentment, often targeted, frankly, at the US Supreme Court. So one mission I've been on in talking about state constitutions and state courts in both halves of the federalism question, localism versus federalism, is trying to remind people about this second option, state courts and state constitutions. Now, happily, I'm not alone on this anymore. The New York Times and the Wall Street Journal, for me, those are probably the two best examples of national publications in this country. One's more on the left, one's more on the right. I haven't done a study on this, but I'll buy you a beer if you prove me wrong, because I don't think you're going to prove me wrong. If anything, I'm understating it. The New York Times and the Wall Street Journal have written more front page stories in the last 6 years about state courts and state constitutions than they have written in their entire 100 plus year histories. Now, these are not nonprofit organizations. They're writing front page stories that they think their readers want to read and will therefore buy the publications and subscribe. What is going on? Why in the last 5, 6 years are these profit-making newspapers writing so many stories about state courts and state constitutions? Well, there's a couple things going on. For a good part of American history, I mean, it's amazing how far we've gone. For a good part of American history, when it came to individual rights, which we Americans cherish, particularly if they're judicially enforceable, but for a good part of American history, the only game in town was the state courts and the state constitutions. The US Supreme Court did very little when it came to individual rights. The US Constitution was largely unenforced. A lot of that changed in the 50s and 60s with the Warren Court. Innovated lots of rights, a lot of it dealing with Jim Crow, a lot of it with criminal procedure, and most importantly, made the Bill of Rights applicable not just to the national government, but to the states. So the key thing that comes out of the 1960s is a world in which a citizen of Cincinnati, unhappy with something the state of Ohio has done, unhappy with something the City Council of Cincinnati has done, now has two shots, not one, to push back on what their local or state government has done, whether it's a law they don't care for, a criminal prosecution that seems too zealous. After the 1960s, every American had two shots rather than one to deal with an overreaching local government. Now, in the 1960s, no one needed the state courts or the state constitutions. Why? If you couldn't win a case on behalf of a criminal defendant in the Warren Court, you should have gone home, looked in the mirror, and said, I got to try another career, because if I can't win there, I can't win anywhere. That was a very welcoming court when it came to individual rights in general, criminal procedure, equal protection, you name it. But of course, you might have noticed the Roberts Court is not the Warren Court. There are two big changes going on. One, for 40, 50 years, we've had a US Supreme Court less willing to innovate new rights. So if we're talking about new norms and new rights, it's just not a court likely to do it as much as it had been historically, or at least in the 50s and 60s. But I would say, most importantly, and this really gets to why the last 5, 6 years we really are paying attention to state courts and state constitutions. The US Supreme Court under Chief Justice Roberts is not only less willing, less likely to innovate new rights, it's also a court that's willing to overrule prior rights decisions. And the two most obvious are Dobbs, the abortion case, and Rucho, the gerrymandering case. And the theme in both cases is for the US Supreme Court to withdraw from the field and to say debates about abortion policy, gerrymandering, among other rights and issues, are going to be handled locally, or they're not going to be handled at all. So that means state legislation, executive branch orders, state constitutional amendments, and most importantly for our purposes, state court decisions construing state constitutions. The Dobbs story is frankly remarkable. I don't think anyone saw this coming, the amount of state activity. I mean, in the state of Ohio, if you happen to be someone who's very disappointed in the overruling of Roe, there's just not a silver lining, it's a gold lining. For people who care about reproductive rights in Ohio, our neighbor Michigan, things are better under state constitutional amendments since Dobbs than they were under Roe. I mean, that ought to be an incredibly striking story, because it's not the conventional story we tell. So let me shift to how I think American constitutional law, what it's going to look like in 10 years. It's a prediction. This is the next book I'm working on. And it's going to look very different in my view. And we'll see if I turn out to be right. But for the students in the audience, I am going to be giving you some ideas for how to win cases in state courts that you can't lose, you can't win in federal court, at least currently. So I think the way American con law, and that's the way we're going to eventually start referring to it, not federal, not state, American constitutional law, in its 51 different sets of options, that we will identify there are three types of right stories. The one we already know is the Brown story, bringing Jim Crow to heel, eliminating apartheid, segregation by race in schools and every other government institution. It's a great story. I think it's justifiably our favorite American con law story. And Brown is going to stay good law, of course, and it's going to be a story that will repeat itself in the future. But the key lesson of the story is the problem at hand is a problem that requires nationalization, not local solutions. All right? That's the Brown story. It's the one story we know. In fact, unfortunately, it's a bit of a victim of its own success, because it's crowded out what are the two other American constitutional law stories that are out there. The second story is probably best exemplified because it's a pretty recent case by Obergefell, the same-sex marriage case. And that's a story where you don't think of it as nationalization is the key, the secret to unlocking the solution to the problem. The Obergefell story is a dialogue story. It's a Brandeis story. It's states and federal government, state courts and federal courts working together to solve a problem that's shifting norms about our conceptions of marriage. And the Obergefell story, most people don't appreciate this. I mean, I bet in your federal con law class, they teach you the 2015 5-4 Justice Kennedy written opinion. And if you don't read that opinion carefully, you're going to not appreciate what the real story is. The real story is a story about how in 1972, the US Supreme Court took a case from the Minnesota Supreme Court. They're asked to decide whether the 14th Amendment allows this gay male couple in Minnesota to get married. The Minnesota Supreme Court rejected the claim under the federal Constitution. They appealed to the US Supreme Court, and in 1972, the US Supreme Court still willing to be quite innovative in new norms recognition. Not a single vote is cast in support of same-sex marriage in 1972. It's a 9-0 decision against the 14th Amendment protecting marriage equality. Well, that's not the end of the story. At that point, the US Supreme Court has put up a big red stop sign. If you happen to care about the issue, you have two options. Option A, embrace misery. Option B, go to the states. Now, the initial state story in dealing with marriage equality is actually not to focus on marriage. It's to focus on no discrimination, sexual intimacy, inheritance rights, and so forth. But by the 90s, the story does shift to the states, and it's a state story. Hawaii takes one step forward, but two steps back when the people of Hawaii amend the Constitution to prohibit same-sex marriage. Vermont's the first state in 1998 to recognize a form of marriage equality, but they actually call it just civil unions, don't use the word marriage. But that 1998 decision does protect benefits for gay couples, does allow for civil unions, and it's not overruled. And then in 2003, if you care for this issue and happen to be on the Obergefell side of the issue, the real key decision is the Massachusetts Supreme Judicial Court decision in 2003, 4-3, written by Margaret Marshall, recognizing marriage equality under the Massachusetts Constitution. The legislature initially responds by overruling it with a majority vote, but it takes 2 votes in that legislature to overrule. The second vote comes up short. So that's the first marriage equality decision that sticks. It spreads to other states through state court decisions, state constitutional amendments, sometimes state legislation. US Supreme Court decides to lead by example in Windsor in 2013 by recognizing marriage equality only for federal laws. And then, of course, in 2015, nationalizes the answer to the policy issue through Obergefell. And in the decision itself, Justice Kennedy acknowledges that there's been a dialogue between the states and the national government over this issue. The states have illustrated that norms have shifted. We at the National Supreme Court are going to recognize the shifting of these norms, and we're now going to recognize marriage equality, nationalizing the solution. So that second American story is one that starts in the states, actually was a US Supreme Court decision against the very issue. It's state developments that lead the US Supreme Court to overrule its own decision and nationalize it. The third story, this is the most provocative, this should be the most head-spinning, and it's the one least taught in any American educational institution in this entire country. That there actually are going to be stories, there have been stories, where if you care deeply about a right, the best way to protect the right is not to nationalize it. The very best thing you can do, because of the politics of the right, because of the local control underlying it, because localities are better at seeing the problem than federal judges, whatever the explanation, we have stories where the very best way to protect something is through local governments. And I'll give you some examples, one dated and some current ones, to illustrate this type of story. So, gosh, it's about 120 years ago that the eugenics movement started. It's a movement, it's an era that should make one deeply humble about trusting the great new innovation, frankly, trusting our elites. This was an idea, eugenics, that was headquartered at Harvard and Stanford, the elite educational institutions in this country. And the whole idea was that we could bring to an end people with disabilities solely by not letting them procreate. So incredibly harsh, because someone with a disability now could be sterilized involuntarily, and therefore they couldn't procreate. What's amazing about that story is a lot of you, probably almost all of you, know what happened to it at the US Supreme Court. Led to the infamous Buck versus Bell decision, 8-1, Oliver Wendell Holmes writing, saying 3 generations of imbeciles, I think he says is enough. It should have been are, I think. But at all events, reject the claim that the 14th Amendment prohibits a state from involuntarily sterilizing someone solely because they have a disability. That's the story most of you know, even if dimly. The story I'm very confident you don't know is one I do in 51 Imperfect Solutions, where the state courts that get this issue all get it right by the verdict of history. Why is it that the states and localities who are so terrible under Jim Crow could do so well with recognizing patent discrimination against people with disabilities? That's the question. I mean, you're going to be an incredible lawyer if you can distinguish when it's Jim Crow and when it's involuntary sterilization. But that is clearly a story where the best solution was localization, and those were the most trustworthy agents when it came to fixing that problem. In more current eras, school funding, the US Supreme Court in 1973 took inequality, had an opportunity to kind of bring Brown versus Board of Education to a proper conclusion, end discrimination based on race, and conclude by ending discrimination based on wealth. The US Supreme Court said no, another close 5-4 decision, Rodriguez, 1973. Many of you may know that story. Most people don't know the other half of the story, how 3/4 of the state courts ultimately use their state constitutions to deal with some of the problems that grow out of property taxes and using property wealth to fund our public schools and dealing with some of the inequities that result from that. I could go on and on about other local stories. Death penalty is another good example, where we tried to nationalize it in Furman at a time for 5 years where we hadn't had a single execution in this country. And when the US Supreme Court tries to nationalize it at the wrong time or on the wrong issue, you sometimes get a backlash. What happened after Furman in 1972? The statistics are so astonishing. I think we were at a high point of 300 executions a year in this country in the 1930s. From the 1930s to the late 60s, it just steadily goes down to zero. We've been at zero for several years by 1972. A lot of countries that share, Western democracy principles had been getting rid of the death penalty. Australia, some European countries. US Supreme Court looks at this trend and says, what could go wrong if we nationalize the solution, abolish the death penalty throughout the country? No one's even using it. Who could object? Well, this must be an American trait. We don't like being told what we can and can't do, even if we're not doing it. Americans revolted. One state after another passed legislation trying to allow them to start doing executions. And this is the tragedy of that case. 300 a year, steadily over, 30 years, down to zero. What happens after the US Supreme Court nationalizes the solution? It goes up to 99 a year by the year 2000. 99 a year. So we're talking hundreds of people executed. Many of them this would never have happened if the US Supreme Court had just stayed out of it. So the impulse to nationalize is not cost-free. That's the big mistake we make. It can be very costly if you pick the wrong issue at the wrong time. And it just turns out, and today's abolitionists, those who want to get rid of the death penalty, their key focus is localism. What happened, by the way, since 2000? We're down to about 25 a year. That is all state by state, the idiosyncrasies of Ohio, Texas, Arkansas, and it has nothing to do with the US Supreme Court. If you care about the death penalty as I do, I'm not a fan of it, even though I have to enforce it as a federal judge. I want it to be zero as a citizen, but I'm telling you, our best hope of getting to zero is not nationalization. Our best hope is, trench warfare, one state at a time. Stop it there, state court decision, state legislation, a governor who doesn't like the death penalty, whatever it is, you use everything in the toolbox in every single state until you're down to zero. All right, so last point, there's a glare, so I can't quite see the clock. This is now I said I'd buy you a beer. Now you're going to be buying me lunches, beers, houses, because I am going to be giving you some really good stuff in the next 10 minutes before we do questions. So if localism is such a big idea, if localism is one of our 3 American con law stories, how can you, particularly the young lawyers here, win cases in state court under the state constitution when the US Supreme Court has put up a big red stop sign about identical language in the US Constitution or similar language, right? So just so we're on the same page, everything in the first 8 provisions of the Bill of Rights, everything in the Fourth Amendment appears in the state constitutions. All right, so that's why you really have 2 shots at an unreasonable search and seizure case, 2 shots at a free speech case, 2 shots at a due process case. How do you win in the state court when the US Supreme Court has put up a big red stop sign? Well, the first key thing is to remember the US Supreme Court has no say over what the Ohio Supreme Court, the Kentucky Supreme Court, or the California Supreme Court does under the state constitution. They are truly irrelevant. In fact, one of the best things about state constitutionalism is you get to act on your impulse that Judge Sutton has really made a terrible mistake as a federal judge construing the federal constitution. And now, instead of just resenting it and just saying what a stupid judge he is, you can go to the Ohio Supreme Court and say, don't make the same mistake Judge Sutton did under the federal constitution. So it's fun, it's liberating. If you're not happy with what the US Supreme Court is doing in a given era, fine, ignore them. Go to your state court, use your state constitution to win. Now, what might be just a couple good arguments that I've seen as potentially super successful? Well, first of all, it turns out a lot of the times the state constitutions are written differently. Different words, different meaning. That's pretty easy. A second one, and this is probably one of my favorites, is the state courts love history. I'm not saying necessarily originalist, but there is no state court judge who's ever served who wasn't proud of his or her state's history. So let me try to illustrate this. Take a free exercise case, free exercise of religion. We have 5 states in this country essentially founded by religious dissenters or minority faiths. So it'd be Pennsylvania, Rhode Island, Maryland, Utah, New Mexico. I was surprised to learn when New Mexico became a territory in about 1850, I think there were 149 religious institutions in the territory, every single one of them Catholic. So that was clearly founded by minority faith. Same with Maryland, founded by Catholics as well. Now, if you're a state court judge in one of those 5 states, and you have a free exercise clause under the Utah Constitution, do you not think you're going to pay attention to that history in figuring out whether it applies to a religious dissenter, a minority faith? How could you not? I mean, how could you not let that history affect your interpretation? Not because you're originalist or living constitutionalist, but because it's part of the state's story. It seems impossible to ignore. This brings up one of the most exciting features of state constitutionalism. The state courts can do something the federal judges and justices cannot. I have no authority in construing the search and seizure guarantee of the Fourth Amendment to pay attention just to Ohio norms and Ohio history. I can't customize the meaning of a national guarantee to account for the story, the values of one state. State courts not only can, they should. I mean, it's one of the best things about being a state judge. They get to customize the meaning of general words to account for their own state's story, history, norms, values, you name it. It's incredibly fun and exciting, and I think as an advocate, it's an incredibly great way to make a difference for your client. Let me give you a third one because I want to make sure I give you time for some questions. So I think I'll probably leave it at this, but this is one that applies half the time. This is what I was referring to when I really think you're going to owe me a house at some point, because this is killer. And no one gets this. This took me 20 years to figure this one out. It's so good. You're like, wow, he's really propping this thing up. Okay, so let me first of all explain that this idea applies to half the cases you will ever argue in state court under state constitution. So half the time, what I'm about to say is going to be very, very helpful to you. What do I mean by that? Well, if you had 4 years' time on your hands and chose to read all of the US Supreme Court's federal constitutional decisions, here's one thing you would find. Half of them are formal interpretation, originalist, fixed meaning, textualist, think Justice Scalia, and half of them are informal, less fixed meaning, more living constitutionalist, more pragmatic, think Justice Ginsburg. It's basically half and half from the beginning of the US Supreme Court. The reason that insight is so critical is that every state court, I mean, this is one thing I know for sure, we appellate judges care about our methods of interpretation. We really do. It really matters to us. I happen to be more on the Scalia side. Forgive me if you wish. I'm proud of it. But I understand the Ginsburg side, and I understood it as an advocate, and I understand it as a judge because I have to report to a US Supreme Court with lots of Justice Ginsburg. So I know them both. But the point is, we appellate judges care about this. Every state court in this country leans one direction or the other. The California Supreme Court today is more of a Justice Ginsburg court. The Ohio Supreme Court is a little more of a Scalia court. What that means is if you're arguing a case in the Ohio Supreme Court and the counterpart federal precedent is written by Justice Ginsburg, it's presumptively wrong by the lights of the Ohio Supreme Court because they're on the Scalia side. If you're arguing a case in the California Supreme Court and the decision at the US Supreme Court is written by Scalia, say Heller, that's presumptively wrong by the lights of the California Supreme Court, which leans in the Ginsburg informal method of interpretation. This insight is so critical because the key problem in state con law for the last 50, 60 years has been state courts unwilling to delink their interpretations of their constitution from the federal constitution. And if you can say that the counterpart federal decision is presumptively wrong, you're 90 yards down a 100-yard football field. You're going to score. You're very well. You still got 10 yards. And if you're playing Ohio State, you might not get there. In fact, we might actually score on you. I resisted mentioning Ohio State football. I'm sorry, I couldn't resist that one. But let me now. I want to take questions. If I don't get questions, I have so many other things I'd love to say. But I want to hear how I've provoked you, hopefully in slightly kind ways. But I can talk about anything, and so fire away.
You have a question, please let me know so I can give you the microphone so everybody can hear
Or
you.
just speak loudly. Yes. Great question, and I have to just say right out, I don't know, and it's something I've thought so much about. I really think a big part of it is the country bringing ourselves out of Jim Crow. I just feel like that's such a sacred story. I mean, it's a sad story that it took so long, but it was a story that ends with nationalization. It's a story where no one says, in retrospect, localism was the way to do it. And I think the question today is every story a Brown story? And one of the things I'm trying to explain is I don't think so. In my Furman story about the death penalty illustrates that you can actually undermine the very thing you care deeply about by pushing too hard on nationalization. I'd like to think there's another feature of this, which is a little too patriotic, but I think Americans, we just, when we think we're right, we think we're right. And we don't like the idea of caring deeply about this free speech value or this search and seizure value and not having it apply to all parts of the country. Like, I mean, we that really matters to us. So once we decide there's some real value in this one idea, we have a hard time being humble about each in their own time. They're going to get there, let them do it on their own pace because it's more likely to stick. I mean, this is one of my big points about localizing. And sometimes the second story, remember, is a cooperation story, which ends in nationalization. But people are much more likely to accept a new norm. A new norm is much more likely to be settled when the people have a role in settling it. If it's imposed on high from 5 people in Washington, D.C. with life tenure, construing a constitution that's unamendable, their first word is gerrymandering. I mean, this is actually one of the great head scratchers in American government circa 2025. If I did a poll of Americans, do you like gerrymandering? The idea that a group of people exercises more power than they legitimately have, that's what gerrymandering is, usually through a legislature. If I were to do a poll about this for all Americans, 330 million or the 180 that would respond, it would be like 90-10. It would be overwhelming that we're against gerrymandering. And yet this same group of Americans is somehow fine with allowing 5 life-tenured justices construing a constitution that can't be amended to announce a verdict about this right or that right for the whole country and take democracy off the table. I mean, that is one of the, you want to talk, there's been no greater form of gerrymandering invented in world government than that conception. And to me, this is why this crown jewel of American government, our US Supreme Court, is at risk. The American people aren't fools. They realize the power it's exercising. They want control of the court. And this is precisely why, if we're going to save the court, and if we're going to continue to be a country that loves judicially enforceable rights, we got to share the workload. It is not right of us to be asking 5 of 9 people to be arbitrating every one of these disputes. And I promise you how it's going to go. It's going to be 50-50. You're going to win half and you're going to lose half. I don't understand why we keep accepting this. It strikes me as a very strange thing. And then to assume the court's only going to honor our perspective, or it'll always be a court that is just like us. Why would you think that? This is a divided country. It's a very big country with a lot of different perspectives. So, but it's a great question. I wish I had a better answer. Just defeated the whole talk. I mean, I couldn't even answer the first question. Yeah. Yeah, so if I had been in charge of arguing Rucho, this is a great question about Rucho, which is very close decision from 2019, where the US Supreme Court actually overruled the Davis decision from 1987, which had said that political gerrymandering is a cognizable question. It's not a political question. But then from 1987 up to 2019, the court, in case after case, could not figure out a test to apply to a political gerrymander to determine when it's so gerrymandered it violates the 14th Amendment, or just as modestly gerrymandered so it's okay. And the innovation, the idea behind the plaintiffs in Rucho was to use this clever computer program, I think developed by some computer experts from, I think, Madison, Wisconsin, so presumably University of Wisconsin professors. And they figured out this way to determine what kind of gerrymanders were out at the edge and what were more traditional types of gerrymanders. Well, the big mistake in that case, and I happen to hate gerrymandering myself and think it's led to a lot of polarization, so it's been really hurtful. But the big mistake in that case is they are auditioning. No one had tried this computer program. They're auditioning a new idea for a gerrymandering remedy that had not been tried in a single state in the country. That is the governor that said, let's move all the elderly to skilled nursing homes. You have no idea how that's going to work out when you haven't tried it anywhere. So the way political gerrymander, so those of you who care about this, you want to change this world, use the next 10 years to go to state courts, whether with computer programs or some other idea, but audition these ideas in a state court where the stakes are lower, where you might get a more welcoming audience, and then you might develop a winning Brandeis type insight that's worthy of nationalization. So that's my real answer to that problem, that it wasn't that it was inherently a stupid idea to nationalize a solution to political gerrymandering. It was that who auditions it for the first time in the US Supreme Court when no one's tried it. That is greed. That is just pure greed and impatience. Now, impatience, I get it. We're not a patient lot, we Americans. But again, it's really reckless to experiment on a whole country, even over something really important, when you don't know how it's going to play out. So, yeah, no, I'm sympathetic with the idea that we should be looking for ways to deal with this. I will say, the state courts is not like they've had eureka moments, but I would say they've not made it worse. I think they have made improvements, and I think the real problem is not as many improvements as we'd like. I think there was a question over this way. Hand, yeah, go ahead. Yeah, I'm afraid it's going to be like the first question. I don't have a great answer. I think it's really hard to generalize. I think some things, um, the technology point's actually a nice way to make this point. Cell phones, other forms of technology that the government can use in monitoring us, that we can use and we can be monitored as a result, actually led pretty quickly to US Supreme Court cases and pretty quickly to nationalized solutions that, for example, a cell phone can't be unlocked by the police without probable cause. That did have a lot of states. So just to remind you here of why the state courts are so relevant, in a given year, the state courts get 50 million cases. In a given year, the federal courts get 400,000. And that's an astonishing ratio. 50 million, 400,000, and all we teach and all we talk about are the federal cases. In cell phone technology and cell phone searches, several states, because they have these 50 million cases, had decisions on this. They went the way the US Supreme Court eventually went, and that did not take a lot of time. That was like a span of 5 years because the technology was making such a big difference in law enforcement. It was leading to so many different search and seizure debates. But other debates, norm shifting, like values, norm shifting, it just takes a little more time. And to me, the question is, do you want your national solution to stick, or do you want it still to be up for grabs? And we'll see. I mean, 10 years from now, it's foolish to predict. But 10 years from now, let's just, ask yourself the question. I'm not telling you the answer. I'm just telling you the questions. Ask yourself, 10, 15 years, will same-sex marriage in Obergefell have stuck? And will we be still trying to nationalize abortion, or will we be deciding that localism fared pretty well in 10 to 15 years? I'm not saying I have the answer. I'm just saying ask the question. And there is a difference between these two nationalization stories. One nationalization story took a very long time, 1972 to 2015. It's a really long time. I happen to think that one's going to stick. And as no less than Justice Ginsburg said, maybe the court would have been wise in 1973, US Supreme Court, to wait a few more years, see what the states do. Remember, every state, you got 50 states, every time one state recognizes the right or deals with the issue, you have one fewer state, one fewer population to be resentful about nationalization. And remember the Furman story. I don't think Americans actually love the death penalty. I do think Americans don't like being told by life tenured people in DC what to do with their lives. I think they're very skeptical of that unless the US Supreme Court justices can point to language in the document and really prove that this isn't politics, but it's a judicial interpretation. That they will respect. They are not going to respect it if they think it's blue-robed, red-robed. And so that's what, those are all questions behind the patience point, but sad to say, I have to acknowledge I didn't answer it. It's such a great point. Yes, there. Yeah, so first of all, my main message is not to tell you what to do. If you have a client or an interest group, you should further their interests. What I am saying is you're a fool if you don't think of both possibilities. That just is malpractice. If you only think of the nationalization story, you're leaving an option on the side. That just doesn't make any sense. The second thing I'm saying is sometimes you have no choice. Think Dobbs and Rucho. There's a big red stop sign. So if you care about reproductive autonomy and gerrymandering, for right now, you have no choice. You can embrace misery or do the best you can in the States. So that's that. Now, the next possibility is no one's decided it. And by all means, if you think you can win the national victory, go for the national victory. That is in the interest of your interest group. You should do it. I'm just telling you, it's not always going to work. Sometimes it leads to a backlash. Sometimes it actually undermines the right. But maybe I can end with this story because I hope this is a way of communicating to all of you how exciting it is to be a young lawyer in 2025. Because some of you are probably a little skeptical that there really is this much ignorance about this second shot. Or maybe skeptical that it's as simple as 2 free throws in a basketball game and who wouldn't take the second shot. American lawyers, they may be bad at math, but they can't possibly be that stupid. Well, let me just say something. It's not American lawyers, it's Americans. We are that stupid. And I'm going to illustrate this with a story that will confirm that we have complete civics ignorance about the role of local and state governments and local and state courts in fixing American problems. And I'll illustrate it with a story most of you know, which is the Black Lives Movement story, okay? So, whether you want to start with Floyd in Minnesota, Ferguson, Baltimore, I don't care where you start, but the gist of it is for a couple decades, we've been trying to deal with a problem we put under the banner of Black Lives Matter, which is dangerous because I think it picks up a lot of things. But I want to talk about what I consider one of the main things, if not the main thing, covered by that banner. And that is communities, local communities in this country where there is distrust between the community and law enforcement. Sometimes that used to be because police were one race, the community was another. That's actually not the problem anymore. This is just a problem between law enforcement and community and lack of trust. Now, there's lots of explanations why there might be lack of trust between law enforcement and a local community, but let me give you one that I know is part of this. It flows from a US Supreme Court decision. The US Supreme Court decision comes from Ohio. It's called Terry versus Ohio. It's a Fourth Amendment case. It's written in June of 1968 by none other than Earl Warren. And in the case, as an election year is proceeding, he kind of pulls out of a hat this idea that the Fourth Amendment doesn't require probable cause before you stop or seize and search somebody, right? The words of the Fourth Amendment are seizure and search. And the US Supreme Court in Terry gets out from under this by saying, well, this isn't a search or a seizure. We're going to call it a stop and a frisk. And having redefined it as stop and frisk, first of all, they should have stopped right there. If it was a stop and frisk and not a search and seizure, then the Fourth Amendment had nothing to do with it. That should have been the end of the case. Instead, they said, what we're going to do is say stops and frisks are different. All you need is reasonable suspicion. And now law enforcement, when they're policing a neighborhood and they're looking at somebody saying, what are they doing loitering on the street? They've been there a long time. I saw them exchanging something. I get to go over, stop them. And here's the big part of Terry versus Ohio that we have not appreciated as a country. I think most Americans are okay with the stop. But when you put your hands on somebody, the frisk, it really is appropriate to demand more than reasonable suspicion. Now, here's the part of that story that you don't know and I hope blows you away. Before Terry versus Ohio in 1968, the state courts had been wrestling with this exact issue. They've been focused on the frisk side of it, and they were not willing to dilute search and seizure when people were actually putting their hands on somebody and searching their pockets, whatever else it was. Suddenly, you get Terry versus Ohio in 1968. In our danger of a single story world, we assume what the US Supreme Court says about search and seizure is good for all 51 constitutions, not just the US Supreme Court and the US Constitution. And lo and behold, over the last 20 years, we have hundreds, if not thousands, of lawyers dedicated to the causes underlying Black Lives Matter. And I'm not aware of a single lawyer making the argument. This isn't a court problem, this is a lawyer problem. going to the Supreme Court of Missouri, the Supreme Court of Minnesota, the Supreme Court of Maryland, the Supreme Court, New York Court of Appeals, and saying, you know, why are we using Terry versus Ohio in New York? Why, after George Floyd, are we doing this in Minnesota? We should be rejecting Terry versus Ohio from Minnesota. We should require probable cause before you put your hands on somebody. I mean, that is civic ignorance. We have hundreds, if not thousands, of lawyers serving the cause of Black Lives Matter. And I promise you something about lawyers, they're not known for being shy about new arguments. That has not been my problem in 22 years as a judge. I get frustrated they make too many arguments. This is sheer, pure, unadulterated ignorance. Now, there's one exception to this rule that no one's made this argument. There's a law review article that doesn't count for much. Worse yet, it's a student note. Worse yet, it's not from Cincinnati, it's from the University of Virginia. But this student note makes every single one of the arguments I've just been making about how the state courts ought to reject Terry, use their state constitutions, and fix some of the causes underlying Black Lives Matter. The author of that story is a fellow named Nathaniel Chase Sutton. That is not a coincidence. That happens to be our oldest child. And I now want you to feel guilty about something. I've not only been working for 20 years to write books, give speeches, and try to bring to light state constitutions and get rid of the civics ignorance. I want you to say it's time for you to pick up the torch and do something, because look at what I'm doing. It's not just all that, but my wife and I are bringing people into the world. I am making him write about state constitutions. And if I can do that, you can at least share the load a little bit. So thank you very much.